operation provides shelter. This involves the parties of the applicant, which is the Republic of Alicanto, versus the respondent, which is the Commonwealth of Rhodesia. The applicant and respondent teams were each allocated 45 minutes to present their respective pleadings, and good luck to both sides.
Please be seated. So everything the President usually says at the beginning has been told by you, so we can, without losing time, start, and I give the floor to the applicant.
Good afternoon, President Sima and Judges Wedgwood and Alvarez. My name is Sebastián Machado, and it is an honor for me to appear before the International Court of Justice this afternoon, pleading on behalf of the Republic of Alicanto. I will speak for the following 22 minutes, and I will be addressing Alicanto's first submissions. The first one referring to the conduct to Ravisian intervention in Alicantan territory and how it contravenes international law, and I will then turn to the intelligence which was gathered to justify this operation. I will then yield the floor to my co-agent, Mr. Guillermo Talura, who will speak for 21 minutes, and he will address Alicanto's last two submissions. The third one referring to the conduct of Ravisian troops while stationed at Camp Terra, and lastly, the assassin, Picardo Donati, and how he must be immediately delivered to Alicanto to comply with his judicial sentence. In consequence, Your Excellencies, we will be reserving 2 minutes for our rebuttal. Mr. President, and may it please the Court. In December 2005, the United Nations Security Council adopted Resolution 5440, by which it authorized a peacekeeping operation inside the territory of Alicanto. Once this operation was completed, Your Excellencies, notwithstanding the allegations of the sexual exploitation and the broadcasting subject of our third submission, Ravisia decided nonetheless to intervene, circumventing the fact, Your Excellencies, that the Security Council rejected not once, but twice an express proposal to intervene in Alicanto. One of the reasons to intervene, Your Excellencies, was the assassination of Alicanto's Prime Minister, Gregory Simurg. But the assassin is at this very moment absconding at Camp Terra, under the jurisdiction of the respondent state, and he is the subject of our fourth submission. It is, Your Excellencies, the intervention in Alicantan territory after the adoption of Resolution 6620, which is of interest to the bench for our first submission. Your Excellencies, I will deal with two arguments in our first submission. The first one referring to the legal effects of Resolution 6620, and I will then turn to the more difficult question on this alleged rule of customary character, which allows for a third state to intervene when they consider that there is a humanitarian situation that so calls for this intervention. Your Excellencies, as to our first ground, Resolution 6620 is not an authorization for the use of force. It is not because a closer look at the practice of the Security Council will show that when the Security Council authorizes Chapter 7 missions, it uses three factors: a reporting duty by an intervening state, a very clear scope of a mandate, and a very precise language to authorize the mission. Your Excellencies, none of these factors are found in Resolution 6620.
Counsel, would you say that, for instance, the authorization given to a coalition in 1990 in Resolution 678 is a good example of a clear mandate?
It is, Mr. President, for one reason, and I understand your concern because Resolution 678 merely referred to the obligations set out in Resolution 6620. But it is in this sense that the mandate is very clear, that is to comply with the obligations to push Iraqi troops back into the state of Iraq. And that was a very clear language and a very precise mandate. Your Excellency, nonetheless, these resolutions and the operation in 1990 did include the other factors: reporting duty by the intervening states, and a very precise scope or language for the authorization.
As the president of the tribunal, I think, though, is adverting, 678 did have some rather vague language, which spoke of the restoration of regional peace and security. So the Security Council does know how to talk in riddles when it wants to, does it not?
Your Excellency, I understand your concern, and Resolution 678 did not use express language such as to authorize the use of force, but it did make reference to the issue of necessity, the use of all necessary measures. And this term necessity, or the question of necessity, has been consistent in Security Council resolutions authorizing for the use of force. Ever since the first resolution which authorized the use of force, Resolution 83, 1950, against North Korea.
Counsel, I'm a little puzzled in that we're immediately jumping to trying to figure out what the Security Council is doing, which sounds like you're being asked, and I think this happens on the other side as well, to second guess the Security Council. Why exactly, other than the fact that you've agreed to be here, does this court have jurisdiction at all? It would seem to be the case that this case is, as the Security Council says in that very same resolution, seized of the matter. Why are we seized of it?
Your Excellency, that question was addressed by this court in the Tehran hostages case. And in paragraph 40, it clearly stated that when the council is seized of the matter in its political aspect, the court can very well be seized of the matter in its legal aspect. And that is precisely what we put forward before the court. And it is also important to note, Judge Alvarez, that in contentious cases before the court, there have been examinations on the legal effect of Security Council resolutions, such as the Lockerbie contentious case, by which the court had to analyze effects of council resolutions as to determine its jurisdiction over the
But
case.
to follow up on Judge Alvarez's question, in the middle of the Kosovo campaign, as I recall, Russia put forward a resolution in the Security Council seeking to have the council determined that the ongoing NATO intervention was illegal. It's true they lost it 12-3, but they thought that the council was the appropriate venue to do so. So why is that not itself a kind of customary practice that should lead us to defer to council jurisdiction?
Your Excellency, and that precise fact is which would lead the court to believe that it is the rejection of two express proposals which actually tells of the will of the Security Council. However, your question leads me to the more important.
But go back to the council and get the council to declare the intervention to be illegal.
Indeed, Your Excellency, and in this case, the respondents did attempt to go to the council to get an authorization for the use of force, and the council expressly rejected this proposal.
But why didn't you get an authorization for the declaration of illegality?
The council decided not to meet, Your Excellency, but this cannot be taken by the court as a decision of the council for one very specific reason. The decision of the council to convene pursuant to Article 3 of the Rules of Procedure of the Security Council is a decision vested on the President of the Security Council and not the council as an organ of the United Nations. And as such, the decision not to convene is not the
Oh, goodness. If anybody who knows anything about the political process of the UN knows that if major powers in the Security Council want to have a council meeting, the President will convene it.
Well, Your Excellency, in that case, then the question here becomes if the practice of a powerful state in the world community will make it law for every state in the world.
Just to have a meeting. So.
They should have, Your Excellency. We completely agree. But your concern leads me directly to the crux of the matter on the first submission. That is whether there is a right of humanitarian intervention in international law.
Before we get to the right, I'm curious again, because the thrust of your comment and your argument is that somehow this is in breach of the Security Council, instead of the thrust of what I thought I read in your brief, which is this is a violation of Article 2.1, 2.4, and you could have mentioned 2.7. And you also stress and you cite the definition of aggression. Are you accusing the other side of aggression? And if not, why not?
We could very well accuse the other side of aggression, Judge Alvarez, in the sense as described in Resolution 3314 of the General Assembly, which defines the act of aggression. That is the presence of troops from a third state in a territorial state without that state's consent. But the act of aggression would nonetheless be a violation on the prohibition of the use of force. And it is this broad prohibition which we're putting before the court. A violation on the prohibition of the use of force as found by this court in the 2005 armed activities case. The presence of Revisian troops inside Alicanto without Alicanto's consent constitutes in itself a breach of this principle enshrined in Article 2, Paragraph 4 of the Charter. And this was the finding of the court, and the remedy we seek is as the court delivered it in 2005, the immediate withdrawal from Revisian troops from Alicantan territory.
But not any conviction of anyone for aggression.
No, Your Excellency, in this specific case, we do not. However, if the court were to find that this is an act of aggression and in itself a breach of the Charter, this would satisfy Alicanto's request. Your Excellencies, the more difficult question before the bench is whether there is a right of humanitarian intervention in international law. But the answer is clearly in the negative. Perhaps the most eloquent fact pointing to this non-existence of the rule is the fact that during the Kosovo crisis in 1999, more than 130 states of the world community expressly rejected that there was such a thing as a right of humanitarian
But in
intervention.
November 1999, Kofi Annan, after the Kosovo intervention had taken place, made a very eloquent speech to the General Assembly in New York, stating in a kind of elliptical fashion, kind of a
So that means that you have to,
So
you have to apply elliptical fashion.
No,
to-
but it was a very, with great deference to my president, it was an attempt to be a spiritual, moral, legal docent, in which he said, essentially, I don't have the quote in front of me, but would there be anybody who would doubt that if we could have a do-over on Rwanda, if there was a coalition of troops that were willing to intervene, but there was no Security Council resolution, that this might be something to be considered?
Your Excellency, I will answer your question twofold. Firstly, to that specific hypothetical situation, or to answer the concern over Rwanda or an event of such a crisis, and I will then answer alternatively if such a right existed, when it could be exercised in international law. As for the case of Rwanda, Your Excellency, perhaps we have two different readings of that same situation, because the Council did act and attempted to expand the United Nations mission in Rwanda to 5,500 troops. It was the world community, after the events in Mogadishu, which decided not to lend its contingents to the Security Council.
It was the U.S. that threatened to veto it, no matter who supplied the troops. Shame on us. But after that, Kofi Annan said, would you want to do it that way again? He said that if the Council's blocked, that may not be at the end of the conversation.
Indeed, Your Excellency, and there is where the responsibility to protect lies in the international community, to cooperate with the Security Council and with the territorial state as to avoid these events from happening. But that and permitting to a state to intervene in breach of the Charter for one single case are two very different matters. And the slippery slope and the implications to allow the latter would be too grave for the international community.
Now, you just mentioned in the same phrase, humanitarian intervention and R2P, the responsibility to protect. Are they the same thing?
We find that they are two in the same in one specific manner. If the respondents attempt to show to the court that their responsibility to protect is a rule of customary character, which allows a state to intervene without the consent of the territorial state, that is humanitarian intervention. However, the responsibility to protect, as espoused in the 2005 World Summit outcome in paragraph 138, or the report of the Secretary General on the high-level panel of threats, challenges, and change in paragraph 203, vests that responsibility to protect in the Security Council. And this would take us back to authorizations, Chapter 7 authorizations by the United Nations. And in that sense, it would be different.
Then in what sense was R2P at all a revolutionary doctrine? If it's all it means is the Council can vote to intervene in a civil conflict. We've known that since the early 90s.
The crucial difference, Your Excellency, is that the Council is now seized, based on this responsibility to protect doctrine, on matters that before were essentially within the domestic jurisdiction of the territorial state.
Excuse me. Article 2.7 says that if the Council makes a Chapter 7 resolution, it's by its nature not covered by 2.7.
Indeed, but in the practice, and under Article 42, during the 90s, the Council has shown that it is now seized of matters which were before that within the jurisdiction of one state. One perfect example is the declaration of the HIV virus inside Africa as a threat to international
But that's my
peace and
point. If indeed, throughout the 90s, the Council intervened in internal situations with a little bit of chiaroscuro that there are there are refugees going over the borders, then why you're saying R2P was really no value added, it did nothing innovative.
merely to exhort the international community to cooperate with the Council as to avoid further Rwandas. And in that sense, Your Excellency, the Council has taken determinations of there being grave threats to international peace and security because of internal displacement without taking forcible actions, such as Resolution 1199.
Council, in the text of the report on our responsibility to protect, is there anything from which you can deduce that you can, if anything doesn't work, that you can go unilaterally? Is there anything in the text that would support such a view?
There is, Mr. President, in the sake of argument, and as well in the report of the Commission on Intervention and State Sovereignty, there is mention on which could be the rule if such a rule existed, and would have certain requirements to be fulfilled. More specifically, in this case, what is not fulfilled is the necessary threshold of violence for a third state to intervene.
Counsel, you make an odd admission in your brief suggesting that the Security Council can actually legalize what was done here after the fact. And you point to Security Council 1244, resolution on Kosovo, for that. Why would you want to acknowledge that possibility, since that only opens up the possibility that right now, during the course of our decision, the Security Council can simply bless what was done to you? Wouldn't you rather stick to the point that this cannot be ratified, no matter by whom, certainly after the fact?
It would make no difference for a case, Judge Alvarez, for one specific reason. Pursuant to Article 14 on the draft Articles of State Responsibility, that is, when a breach of international law expands through time, it is to be considered on the first date when the breach occurred that there is a violation of international law.
What authority do you give the ILC draft articles or articles,
We
like
give-
Article 14?
We consider, Mr. President, that they're reflective of customary law. And the International Law Commission, as entrusted by the General Assembly to codify existing law, has relied heavily on the practice of states and opinion juries when codifying rule in Article 14.
But why does the International Law Commission then regularly say in its accompanying text to reports that no distinction is made between articles that are a mere codification and articles that embody progressive development?
Although that is true, President Sima, in the case of the draft articles on state responsibility, many articles, especially those at the beginning of the report, are expressly said by the Commission to constitute customary international law. In this case specifically, it is expressed by the Commission, more specifically Mr. James Crawford, who was the special rapporteur in that specific case, that this constitutes or reflects customary law. And the point being, Judge Alvarez, that if the moment of the breach is the 1st of August, when there is the ferrying of Rhodesian troops into Alicantan territory, then if there was a Security Council resolution or the prospect of a
Where would you draw the distinction between what's in the beginning of the draft articles and what comes afterwards and is more progressive? So could you tell me an article? What is it? How many articles do we have there? It's just that the first part in the beginning. So 28 are mere codification, the other 28 are progressive, or?
No, Mr. President, allow me to restate Alicantan's position clearly. Some articles on the draft articles on state responsibility do reflect customary law, but not all of them. It is specifically in the initial part of this codification that we find the most used and the ones relied to by the court.
So what article would you regard as the farthest away from codification and most venturing?
I'm very interested in that.
A good example, Your Excellencies, would be Article 42 or articles which refer to the standing of parties before the International Court of Justice.
So what's so great about Article 42? I mean, what's so progressive?
Mr. President, they have a direct conflict between the holding of this court in the Barcelona Traction case when it referred to obligations erga omnes and the standing that a state could have before the court, and that of the work of the International Commission itself. And this is, with all due respect, not of specific relevance for the case at hand.
Is that really Article 42 or would it be Article 48?
48, Mr. President, I stand corrected. Your Excellencies, the point in hand is that Rhodesia breached international law on the 1st of August of 2008.
Now, let me just ask you whether, and maybe your co-counsel are going to handle it, so tell me if I'm premature, but you're also trying to cover the argument under Article 53 of the Charter? Or will that be addressed by your co-counsel?
No, Article 53 of the Charter has been relied on by the respondents.
Indeed.
But, Your Excellency, the court must keep in mind that Article 53 refers to forcible actions by regional arrangements only with authorization of the Security Council. And this is clearly expressed.
Now,
in the text.
after the events that occurred in both Rwanda and Kosovo, there was a discussion in the Security Council what Article 53 meant in the new days. And the view often taken was that because ECOWAS had been put to wait for the Security Council to act, and this is really Judge Alvarez's point in a different form, and the Security Council was very slow-footed on both Sierra Leone and Liberia, ECOWAS had to go forward on its own motion, and thereafter was blessed by the Council. And Danilo Turk, ambassador from Slovenia, among others, drew from this the conclusion that in a real sense, Article 53 had been rewritten. It had a new customary gloss, a new gloss of practice. So can't we indeed say, as Judge Alvarez was adverting before, that the regional organization to which you belong was sufficient warrant for the intervention?
Your Excellency, simply put, no.
Because?
For two reasons. The first one being that we contend that Article 53 has not been overridden as to allow for there being collective action by regional arrangements without Security Council authorization. And the most important one here is that ARFAN was not the actor which intervened in Alicante. It was Revisia in its unilateral capacity as endorsed by ARFAN. And this is clearly expressed in paragraph 30.
But then distinguish Sierra Leone and Liberia for me.
Indeed, and both cases counted with the consent of the territorial state.
At all moments in the intervention?
Indeed, Your Excellency, the question was whether the ex post facto authorization had any legal weight for that specific scenario.
How would you comment the expression that through one practical case, something has become a customary gloss? An expression used by my distinguished co-judge. So if there is a practice out there which has in the literature been regarded as not admissible, let's say, I think most of the voices were that ex post authorization should not be seen as authorization proper. Then you have the case in Africa, nobody else wanted to intervene. No other country outside Africa wanted to send troops, so everybody is happy that the regional organization steps in. And then the people who like that say, now customary law, instant custom, hothouse custom. You have a view on these matters? I mean, I guess the other side will have a view, but I'd like to ask you to.
Absolutely, Mr. President. And on that point, we fall back on the findings of this court in the North Sea continental shelf cases. The court would still have to satisfy itself that there is uniform state practice with accompanying opinio juris, for there to be a customary rule of international law, which in this case, there clearly isn't.
Now, Security Council practice, would that be state practice in the sense of the North Sea continental shelf criteria?
It would not, Mr. President, but pursuant to the findings of this court in the construction of a well-advisory opinion in paragraphs 26 and 27, the practice of the Security Council is important to determine under which basis or which power the Council is acting. And for that, we do rely on the practice of the Security Council. Alternatively, Mr. President, we would argue that Article 53 could not be overridden by means of custom, and that is because Article 103 makes specific relevance.
But it certainly is the case that the UN Charter has been reinterpreted on many different occasions, counting abstentions as the same as concurrences for the purpose of going forward with the P5 and the Security Council. That was done by just sleight of hand and eventual acceptance.
Indeed.
So, and there always has to be a first case. If this court is to intervene when you begin to have the evolution of a practice, we cut off the possibility of the evolution of a different interpretation of the Charter.
That could be so.
How does that go to our role?
Your Excellency, counting abstentions as a type of vote and permitting the departure from one of the paramount principles of the Charter, the prohibition on the use of force, are two extremely different things. And we consider that the court should at any rate rely on the fact that there is indeed a customary
Well, then
rule.
let me ask you a parallel case. Let's say some applicant came before us and said that the new practice, indeed, of the Security Council in reading threats to international peace and security very broadly to cover what are de facto domestic cases. I mean, again, you can wave your hands with refugees going over borders, but the South is well aware that in the 1990s, the UN and the Council began to intrude much more deeply into the civil affairs, the internal affairs of countries. By the same token, this court could cut that off by saying that's not what Article 39 was meant to cover. The Security Council itself acted illegally.
Your Excellency, seeing that my time's up, I have 30 seconds to answer
I
this.
think you have, you have time to answer.
Thank you, Mr. President. Your Excellency, although the bench makes a very good point on reinterpretation of Charter articles, we do find that this is not merely a reinterpretation from Article 2.4, which is a blanket prohibition on the use of force, but it is a departure from one of the principles which founds the United Nations and has consistently found to be a blanket prohibition not only by the United Nations.
But you're dodging the point, with the indulgence of the
No,
President.
we'll have a very lively deliberation on this point.
But just one last quick question.
Very
Article
lively
39,
colleague, anyway.
Article 39, in the view of the South, does not cover this roving remit to intervene in the internal affairs of countries. And you're saying that's different because...
Your Excellency, Article 39 permits for the Council to take determinations on what threatens international peace and security. And indeed, as you mentioned, and it has been put forward by the applicant, that during the 90s, the Council adopted a wider discretion on what meant as an international threat to peace and security.
So they are immune from judicial review, in a sense, if we think their interpretation is itself an excessive reach of the Charter.
Not precisely judicial review, Your Excellency, but the practice of the Council is to address issues which do threaten the international peace and security with a wider scope. And this, in our view, does not constitute a breach of the Charter itself, but a different practice of the Council, an abysmally different case to permitting a state to intervene without Security Council authorization. Your Excellencies, we will rely on our written submissions to substantiate our second submission on the intelligence gathered. If there are no further questions, I will now defer to Mr. Otálora.
Okay, thank you very much.
Thank you very much.
I call on your colleague to continue the arguments for the applicant. You have the floor, sir.
Mr. President, members of the court, my name is Guillermo Otálora, and as co-agent for the Guillermo Otálora, Mr. President.
Otalva, okay. Yeah, because I couldn't read it here. Yes.
As co-agent for the Republic of Alicanto, I will address our third and fourth submissions. Our third submission deals with the conduct of the Ravisian troops while stationed at Camp Tara. This comprises both offensive radio broadcasting and exploitative use in prostitution by the Ravisian troops, both before the 1st of August of 2008 and this broadcasting which continued after that date, which marks the difference between UNMORPH and the commencement of Ravisia's illegal operation in Alicantan territory. Our fourth submission, Your Excellencies, deals with Mr. Picardo Donati, the Alicantan citizen who is fugitive from criminal process and should be surrendered by Ravisia from within Camp Tara to the Alicantan authorities for his judicial sentence to be carried out. Mr. President, may it please the court. Regarding our third submission, Your Excellencies, I will firstly address the question of attribution. That is, whether the conduct before the 1st of August of 2008 is attributable to Ravisia. Secondly, Your Excellencies, I will address the question of the exploitative use in prostitution, and particularly Ravisia's obligation of due diligence with regards to this conduct. Thirdly, Your Excellencies, the question of the broadcasting. And regarding, Your Excellencies, the question of attribution, this conduct is attributable to Ravisia, notwithstanding the fact that the troops, the organs of the state of Ravisia, were seconded to the United Nations. This is because the full conduct was squarely outside of the mandate of the mission, and there is simply no precedent in international law allowing for a customary rule to attribute exclusively to international organizations that conduct which falls outside the mandate of the peace.
Counsel, does that apply to the radio broadcasts as well as the prostitution?
We submit that it does, Your Excellency, and it does because it was not covered by Resolution 5440. While the respondents might allege that this is covered by paragraph 6 of that resolution, establishing a public information capacity for UNMORPH, we submit that it is not, Your Excellencies, because it must be read in accordance, firstly, with the UN Charter as a derogation from state sovereignty. Chapter 7 resolutions establishing mandates should be construed restrictively. And secondly, in the context of the mandate given to UNMORPH. And the whole object...
Where do you derive authority for what you said, that in case of Security Council resolutions based on Chapter 7 that limit or kind of intrude upon sovereignty of target states, these resolutions must be interpreted restrictively? Can you give me authority for that?
Indeed, Mr. President, and our authority for that are the repeated memorandums by the UN Office of Legal Affairs establishing that the UN mandate, especially with regards to public information capacities, should be read in accordance with the mandate and strictly with the consent of the receiving state. But most importantly, Your Excellencies, it is the context of this resolution. This resolution read as a whole provided for a mission in order to diffuse the border conflict between Alicanto and New Benue. And Your Excellencies, this expansion of the broadcasting, aside from the public information capacity in order to provide security information, was not in accordance with the whole mandate of the mission. It exceeded the purpose of that mandate, and therefore, Your Excellencies, it is not attributable to the UN as an international legal subject, but to Ravisia. And this is precisely the reason why, Your Excellencies, it is also an internationally wrongful.
I'm just a bit confused, because I take it the broadcasts occur both during the tenure of the Security Council resolution and after it expires, right?
This broadcasting continued after.
So there's you're charging liability even for the period during the Security Council resolution.
Correct, Your Excellency.
Isn't it an absolutely ordinary concomitant of any military operation, even one that is relatively passive, to have psyops, psychological operations, to try to win support in the local community to try to explain the nature of the mission, to try to set a milieu in which the mission can be effective. Everybody remembers the UN's failure in Rwanda with Radio Mille Collines, which was not blocked. The obverse of that is you'd want broadcasts that make the mission succeed.
Certainly, Your Excellency, it is desirable for broadcasting for the mission to succeed, and that was provided for in the Status of Forces Agreement between Alicanto and the UN at paragraph 11 of that agreement. But what was not covered was a subsequent expansion of this broadcasting for educational radio programming on reproductive health, Your Excellencies, or access to education. This has nothing to do with the mandate of the mission, which again was exclusively related to a border conflict related to drug smuggling and
Since we know that there was an apparent problem of sexual abuse by peacekeepers, isn't sexual education rather pertinent to warn the populace of the hazards they face at the hands of the UN force?
It is indeed pertinent, Your
So
Excellencies.
it's part of the mission.
It is indeed pertinent, Your Excellencies, but it is not part of the mission itself. This mission was very limited, Your Excellencies. It was only with the purpose of diffusing this border conflict, and it was not a more extensive peace-building operation as may be found in places such as Kosovo or Timor-Leste. Therefore, Your Excellencies, Resolution 5440 only established a very limited mandate. And this, again, Your Excellencies, is precisely what renders this conduct...
So you want us to parse the content of the UN's broadcasts?
Pardon me, Your Excellency?
You want us to scrutinize the substance and locutions and phrases and broadcast content of the UN's broadcasts in the area? And those that are beyond the mandate become attributable to the country that is donating the troops?
Indeed, Your Excellency, in that sense, the content should be examined, not as for the rightfulness of the content, but only as to whether it exceeds the resolution and the consent given in the Status of Forces
I'm
Agreement.
confused as to why these radio broadcasts are so objectionable. You mentioned sovereignty, but sovereignty is not a legally defined term. What precisely is wrong, other than the fact that it may violate a provincial law of one of your provinces? Especially odd because this is occurring on your territory. And you have human rights obligations that I think the radio broadcast, at least arguably, fulfill. So aren't you violating your human rights violations by blocking the broadcast?
We are not, Your Excellency, and let me address firstly that issue of whether Alicanto is violating these obligations under Article 19 of the ICCPR or under the Convention on the Elimination of Discrimination Against Women. And Your Excellencies, none of these are being violated. Article 19, paragraph 3, allows for limitations to freedom of expression if they threaten either public morals, national security, or rights of others. And Your Excellency, both public morals and public security were being threatened and are still being threatened, Your Excellencies, by this broadcasting which is being performed by the rebellion troops.
Is it really a purely unilateral method to determine or define what the exceptions in Article 19.3 of the CCPR are? I mean, is it really in your hand to say what we regard as going against public morals or the order public? That's for us to decide, more or less, like the United States reserved to decide what domestic jurisdiction was in the famous Connolly Amendment. Is it purely your matter, or is there something like an international standard that you would have to take into consideration?
We respectfully submit, Mr. President, that it is a matter for Alicanto to decide upon. And this is because public morals are not a legally defined term. And as affirmed by the European Court of Human Rights in cases such as Handyside versus the UK or Mueller versus Switzerland, it is for the margin of appreciation of the individual state to determine what might be the legitimate
Counsel,
aim.
and if we decide that the margin of appreciation, as we have said, is not a customary rule of international law and does not apply outside of the European Convention of Human Rights, what then?
We submit, Your Excellency, that this rule of margin of appreciation, even if it is not of customary character, does apply with regards to freedom of expression under Article 19 of the ICCPR, and it was upheld by certain committee members in Hertzberg versus Finland by the Human Rights Committee.
Is that binding on this court?
It is certainly not, Your Excellency, but it may be taken into account as an interpretation under Article 38(1)(d) of this court statute as the organ entrusted by the ICCPR in order to determine whether there have been breaches of that convention.
Now, Counsel, you started on the attribution argument, but we didn't let you finish. And I am curious what you make of Article 46 of the SOFA, which seems to say that anything that occurs during the peacekeeping operation including locally recruited personnel, shall be immune from legal process. It sounds very much from that provision, as well as others in the SOFA, that if anybody is guilty of anything, and let's assume for a moment you're right, it's the UN. And that seems to be the decision of the Barami case. Can you comment on that?
Indeed, Your Excellencies, and several points must be made in this respect. Now, firstly, as to the import of Article 46 of the SOFA, this article applies to all members of the mission with regards to acts and words done in an official capacity. Therefore, this limitation also exists with regards to the mandate of the mission. And if this conduct is outside of the mandate, then immunity does not.
But by the same logic, I'm afraid, it surely was not within any military mandate of the sending country in its national capacity to have its troops commit sexual abuse with young girls, even consensual, so-called consensual sexual abuse. And by dint of that, it's an entirely private act that would have recourse neither against the government of the sending state nor against the UN.
That is a very important question, Your Excellency. And let me address firstly the holding of this court in the Berami case with regards to Article 5 of the LC's articles on the responsibility of international organizations.
I mean this court, you mean the European Court?
Excuse me, Your Excellency, the European Court of Human Rights in Strasbourg. And then the question of private conduct. Now, Your Excellency's effective control is needed for the conduct to be attributable to the organization. And in order to determine effective control, the mandate is certainly relevant, as held by that court, the European Court of Human Rights. But for attribution to states, it only suffices that the status of the person conducting this sexual exploitation is that of an organ of the state under Article 4 of the ILC's Articles on State Responsibility. And these are not purely private acts. The ILC, in its commentaries to Article 7 on ultra-virus conduct, makes reference to two criteria, which are applicable here in order to determine private acts from ultra-virus conduct. That is, firstly, whether a pattern exists, and secondly, whether the means given to the agents as agents of the state empower them to move.
But your mention of pattern does bring one back to the point, which is that ultimately the conduct of a UN peacekeeping force is up to the UN force commander. In this case, the force commander happened to be from Rhodesia. It could as easily have been from Uruguay. And therefore, you would not follow logically to attribute it to Rhodesia, but rather to Uruguay, or to the UN. In other words, the discipline that's necessary to keep young men and young women in their tents at night, not fooling around, but rather reading and doing constructive bar review for their later careers, is up to this is a matter of discipline. When you look at ideas of command responsibility under international criminal law, it's the commander who has a duty to prevent before the fact. And very much, therefore, it's the UN force commander who was the one that bears responsibility for having failed to keep his troops at home at night.
In that case, Your Excellency, we submit that it would be both the individual criminal command responsibility of Major General Leila Skalark, but also Revesia's responsibility. And let me then turn to
But Revesia cannot countermand its UN mandate. The Revesian commander was operating as a UN commander, not as a Revesian commander.
Correct, Your Excellency. However, Rhodesia as a state, under its due diligence obligations under the Convention on the Rights of the Child, does have a duty to prosecute any acts which may be suspected of having been sexual exploitation, including these acts under paragraph 21 of the special agreement submitted to this court. And that is a very important point.
So what you're really relying on is not the failure to prevent, but the duty to prosecute after the fact.
It is both, Your Excellencies.
Do you know for a fact that there have been no prosecutions after the fact?
There have been no prosecutions, Your Excellency. Under the clarifications to the compromise, no sex-related charges have been brought against the members of the Revesian contingent of UNMORPH for these alleged conduct. And Your Excellencies, if this court were not convinced as to the question of attribution, in any case, Rhodesia still enjoys exclusive criminal jurisdiction over the Revesian contingent members under paragraph 47 of the SOFA.
Could you find anything on that question in the Geneva Conventions, 1949? Just any answer, any?
Indeed, Mr. President. And the respondents in the written submissions have submitted that international humanitarian law applies to the situation. And under the customary international humanitarian law, given that none of these states are parties to the Geneva Conventions or their protocols, the sexual acts, including indecent assault or sexual assault upon children or women, are to be criminalized by states. And this was held by the ICTY in several cases, from the Furungia decision in 1998 to the more recent Milutinovic judgment in 2009.
Counsel, you mentioned the SOFA, and you relied on it, and perhaps I led you there. But is it your view the SOFA is still in effect?
It is not still in effect, Your Excellency. However, under Article 47 of the SOFA, Revisia enjoyed exclusive criminal jurisdiction over these persons.
But if it's not in effect, then what matters what Article 47 says?
Our second point on this matter, Your Excellency, is that in any case, Revisia enjoys personal jurisdiction over these persons. And enjoying personal jurisdiction under international law, Revisia should prosecute those
But
crimes.
if these are private acts, you have jurisdiction too, as the territorial state. Have you investigated and prosecuted these acts? And then put out an Interpol warrant for the extradition of the offending soldiers?
Your Excellency, these acts have not been prosecuted before Alicantan courts. But
You could, if they're private acts, by your logic.
Especially since you make a habit of prosecuting people in absentia anyway.
But in any case, Your Excellencies, we still do rely on our primary point on Article 47 of the SOFA, because it does apply for those matters which were under Resolution 5414, that is, before the 1st of August of 2008.
But it does seem to me that before you try to attribute responsibility to Revisia, you would be obliged, almost as a good hands doctrine, clean hands doctrine, to show that you had discharged your capacity to prosecute these matters.
We beg to differ, Your Excellency. We take a much more limited interpretation of the clean hands doctrine, as has been suggested by several members of this court, including Judge Schreible in his dissenting opinion to the Nicaragua case. Your Excellencies, under the clean hands doctrine, the state must have contributed to the illegal situation for clean hands to be raised as a bar against it.
Failure to arrest during a continued tenure of peacekeepers, who then become unilateral peacekeepers, would seem to me to be a state failure.
However, Your Excellency, that failure to arrest is due to two reasons. Firstly, the legal one, that the SOFA was still in effect before the 1st of August of 2008. And secondly, that it has been simply impossible for Revisia to mount an armed resistance against Operation Provide Shelter.
Has this court ever taken a stand on the clean hands doctrine?
Your Excellency, it has not. This doctrine has been found mostly in separate and dissenting opinions before this court. If this court were to hold that
Can you
is...
give me a couple of examples?
Your Excellency, Judge Hudson's separate opinion on the diversion of the river from underwater Meuse.
Was that really clean hands or more the exception non ad impleti contractus, if that's the correct mispronunciation?
Miss Italian.
It was referred as such by Judge Hudson from the PCIJ. However, Judge Schreible did interpret Judge Hudson's separate opinion.
Has the International Law Commission expressed a view on clean hands?
Not that we are aware of, Your Excellency, but in any case, the clean hands doctrine does establish this limited interpretation.
If I ask you the question, just can you just have a look at the ILC draft article and see whether you find something on clean hands? Where would you look? Because your team is an expert on the first half and second half of the, so where would you look? Under what chapter or section would you look?
On the chapter of standing, Your Excellency.
What?
On the chapter on standing, Mr. President.
Is there anything in the ILC draft articles on standing?
On invocation of responsibility by the injured state. And those articles do not provide any clear basis for the clean hands doctrine under international law. Now, Your Excellencies, let me turn now to the issue of Mr. Picardo Donati. And having submitted that this conduct is fully attributable to Revisia, and that Revisia bears full liability for these acts, including for not fulfilling its due diligence obligations, our fourth submission is that Mr. Donati should be immediately surrendered.
Where do you get this due diligence from? Which it's very popular with the applicant. What is there a customary law that you have to apply everything with due diligence, or where do you get it from?
This due diligence obligation is contained in the general obligation to prevent under Article 2 of the ICCPR and Article 34 of the Convention on the Rights of the Child, establishing the need to establish all unilateral, bilateral, or multilateral measures to prevent sexual exploitation. And Your Excellencies, the Human Rights Committee, in General Comment number 31, has stated that certain grave human rights violations do merit prosecution, a prosecution which has not even been attempted by the respondent state.
You are arguing into a very specific direction, but my question was more related to due diligence as a notion in general international law and where you can apply it, what it means, etc. What would be leading authority on due diligence?
As a notion under general international law, it would be the Corfu Channel case, Mr. President. And in the Corfu Channel case regarding acts done within the territory of a state, this court did hold that there was a due diligence obligation binding on Albania.
Right, sorry?
That there was a due diligence obligation binding on Albania. However, Your Excellencies, we do rely primarily on the obligations established under the ICCPR and the Convention on the Rights of the Child, specifically for prosecution of grave human rights violations. Now, Your Excellencies, turning to the issue of Mr. Picardo Donati, he is still absconding at Camp Tara, and Ravisia refuses to surrender him, invoking the non-refoulement obligation, again under...
But your country, sir, if I'm not mistaken, reintroduced the death penalty after a lapse of a great many years. Is that not true?
It is true, Your Excellency.
And you say that there's nothing in the jurisprudence of the Human Rights Committee that would preclude what was done by your state, citing something that was from a case from 1989. Have you looked at the more recent jurisprudence, say, on the Philippines?
Your Excellency, the Human Rights Committee has suggested that there is a prohibition of reintroduction of the death penalty with regards to the ICCPR, but none of these parties are parties to the second optional protocol to the ICCPR.
It has nothing to do with the second optional protocol. It has to do with Article 6, Paragraph 2. In countries which have not abolished the death penalty, excuse me, where'd it go? I've lost it. In any event, the view that's taken is that although that the covenant is to be construed in a abolitionist spirit, one may or may not agree with that. But that's the standing jurisprudence of the Human Rights Committee. I know whereof I speak. And the view is that if a country has abolished the death penalty, yea, even suspended it, it cannot reintroduce it.
Your Excellency, with respect to the Human Rights Committee, we submit that the opinions of states parties to the ICCPR should be given more weight, and the resolutions and the moratorium to the death penalty adopted by the General Assembly last year and this year.
You mean the views of individual states should be given more weight than the views of the committee, or you want to say that, let's say, some collective view would supersede committee views?
The collective view, Mr. President.
So where's the collective view in your case?
The collective view, Mr. President, is precisely the absence of a view as to this abolition in Article 6 of the ICCPR, which is
But it's
otherwise
quite
absent.
explicit, and I've now recovered my wits. In Article 6, Paragraph 2, it says, in countries which have not abolished the death penalty, the sentence of death may be imposed only for the most serious crimes. The committee's view is that once you've abolished it, there's no shelter in the covenant for the death penalty. Once it's abolished, it's abolished. One-way valve.
Mr. President, if I may have further time.
And therefore, that
Yeah,
the
yeah.
surrender would be impermissible.
You have all the necessary time.
To aid and abet, so to say.
No.
That the surrender would be, if you will, an act that contributes to a violation of the Covenant on Civil and Political Rights.
We submit to Your Excellencies that that prohibition of reintroduction is not contained in the text of the ICCPR.
It's in the case law, ohchr.org.
It is indeed, Your Excellency, but again, with respect to the Human Rights Committee, we take the view that the ordinary meaning of this text and the context of these provisions pursuant to Article 31 of the Vienna Convention do not provide for a prohibition of reintroduction.
But assume for the sake of argument that the jurisprudence is clear and that the committee, under its new general comment, is entitled to substantial deference by the states as to the authoritative interpretation of the covenant. So assume it is a violation of the covenant. Does that indeed give the respondent the sufficient claim to have failed to surrender?
Not any violation of the covenant, Your Excellencies. If this court were to find that this is a violation of the covenant and that it amounts to an arbitrary deprivation of life, then our claim would fail. But, Your Excellencies, we submit that reintroduction in itself is not prohibited by the ICCPR, and in any
But
case...
assume it is. The premise of my question is it is prohibited.
Indeed. Then, Your Excellencies, if this court were to find that this deprivation of life is arbitrary pursuant to Article 6.1, our claim would fail. But it is not arbitrary, Your Excellencies.
But Article 6.2 wouldn't count in the same fashion.
Article 6.
You're picking and choosing between some paragraphs of Article 6 as to which would be a permissible defense against the failure to surrender the defendant.
In our submission, a permissible defense would only be arbitrary deprivation of life, Your Excellencies, because this non-refoulement obligation cannot be read so extensively so as to provide for a full derogation of a state's domestic judicial jurisdiction.
What do you base that on? Last question, Mr. President.
Your Excellency, we based it on the limited character of this non-refoulement obligation, which has been asserted only within a territorial context by the Human Rights Committee, and, Your Excellencies, only with regards to arbitrary deprivation of life. The opinions of the committee with regards to this issue have always made express reference to the paramount right to life, but, Your Excellencies, the procedural defects which may be found in Picardo Donati's trial in our submission do not amount to arbitrariness, because under paragraph 48 of the special agreement submitted to this court, the trial was overall fair. And
If you, final thought, just which you can respond to in writing. If you think that the Soering case is good law for the European Court of Human Rights, then you might suppose that the same kind of surrender under the covenant would be seen as impermissible if it contributed to a violation of covenant provisions.
yes, Your Excellency, but the Syrian case dealt with cruel, inhuman, and degrading treatment with regards to the death row phenomenon, which is not present here. And while the respondents have submitted in their written briefs,
Because you intend to execute him right away.
it has been indeed an objection to that doctrine made by several committee members. However, Your Excellencies, we do submit that the law as it stands does not provide for a prohibition with regards to the non-refoulement obligation in this specific case. And Your Excellencies, there is no possibility, the respondents have not substantiated any possibility of cruel, inhuman, or degrading treatment with regards to Mr. Donati. They have relied exclusively on the duration of the execution.
The missing link, though, is you're saying there are degrees of illegality, and surrendering someone to a sentence which is illegal under international law is something you can do a sort of a gradation of. You can do a pH test. It's not terribly illegal, just a little illegal. That's a very funny posture to take.
I'm sure Council will give it deep thought. Okay. Well, thank you very much. We really have run out of time. That means I now call on the respondent, right? Is that? Yes. Thank you very much.
Thank you, Mr. President.
And okay. You have the floor. You're Ms. Lee, right?
Yes, Mr. President, Your Excellencies. May it please this honourable court, my name is Annabelle Lee, and I appear today as agent for the respondent, Commonwealth of Rhodesia, with my co-agent, Mr. Mahesh Rai, and our attending counsel today is Ms. Noor Davis. Your Excellencies, I shall be addressing the first two pleadings in this matter, A and B, namely the presence of Rhodesian troops in Alicanto since the 1st of August 2008, and secondly, the issue of the classified intelligence data. I will be speaking for 22 minutes. My co-agent, Mr. Rai, shall address the remaining two pleadings and will be speaking for 21 minutes. We would like to reserve 2 minutes for a surrebuttal. Your Excellencies, in response to the applicant's submissions, we also have 3 main submissions to make on the grounds of the legality of Rhodesian's intervention in Alicanto. Firstly, the applicant submitted that the respondents may not rely upon resolutions 5440 and 6620 to justify their intervention. Your Excellencies, as we made clear in our brief submitted to this court, the respondents do not wish to rely upon this ground of justification. Secondly, Your Excellencies, the respondents submit that there is no customary right of intervention on humanitarian grounds. We would submit to the contrary, that there is in customary international law a right to intervene on humanitarian grounds, and that this applies on the facts of the present case. Thirdly, Your Excellency, and in the alternative, we would seek to rely on Article 53 of the United Nations Charter, which permits regional organisations to take action. Firstly, turning to the existence of a customary right of intervention on humanitarian grounds. To clarify, Your Excellencies, as Judge Alvarez put to the applicants, we submit that both humanitarian intervention and the responsibility to protect doctrine are founded upon the same fundamental principle that intervention based on humanitarian grounds is permissible in particular circumstances. And we support this with both the requisite state practice and opinio juris as outlined by this court in the North Sea Continental Shelf.
Counsel,
All right.
Sorry.
Go ahead.
I'm interested in your suggestion you're not going to talk about the Security Council resolutions, and I'm curious why that would be. Are you suggesting that we should not consider the possibility of material breach of those resolutions by Alicanto, and your response as being consistent with, say, the US, UK enforcement of no-fly zones after the material breach of Iraq in Resolution 678, which another judge on this court has made lots of. So why not?
Your Excellency, I understand your concern. However, it is the respondent's case that our intervention in Alicante is primarily justified upon humanitarian grounds. Alternatively to that, we would suggest that this is a regional arrangement. Our further alternative to that would be our reliance upon Security Council resolutions. However, in the interests of time before this court, we rest on our primary submission that our intervention is justified on humanitarian grounds.
But for the privacy of our chambers, we choose to look at 6620
Very
and
well,
say
Your
that, for
Excellency.
example, language like be prepared to provide humanitarian assistance under a chapeau that says it's a continuing threat to the peace and security of the region, that might be sort of pretty close to Chapter 7.
Yes,
You
Your
wouldn't eschew that, I
Excellency,
take it.
I would be much obliged to discuss this matter further.
Thank you.
Turning first to the customary right of intervention on humanitarian grounds, the applicants have raised one instance of state practice, namely the NATO intervention in Kosovo. And as the applicants highlighted, this did, and we concede, draw a degree of adverse reaction from the international community. However, we would seek to distinguish NATO's intervention in Kosovo from the facts of this present case. But before I do this, Your Excellencies, let me indicate the positive state practice and opinio juris upon which the respondents rely to show this rule of customary international law. Firstly, there is the African Union's mission in Darfur in 2004, the US, Iraq, and France's intervention in Iraq in 1991, ECOWAS's intervention in both Liberia and Sierra Leone. Regarding Kosovo's intervention, we would distinguish that state practice from the present case in two respects. Firstly, that the controversy regarding NATO concerned, first of all, that NATO intervened in a non-NATO country and thus acted outside its regional mandate, and that is not the case in the present circumstances.
But when you start distinguishing cases from the cases that were put forward by your opponent, okay, that's a legal operation, which is fine, but could you give me just, let's say, 4 or 5 clear-cut cases where the international community of states has really recognized that a humanitarian intervention was legal?
Yes, Your Excellency. Primarily, we would rely upon ECOWAS's intervention in Liberia and Sierra Leone, which were justified on humanitarian grounds, and not only did they not attract adverse reaction from the international community, but were actually positively welcomed by the international community.
Were there many states around that said, applauded and said this was right under international law?
Yes.
Yeah?
Your
Many?
Excellency, the Security Council itself in Resolution 788.
States.
Your Excellency, I'm afraid I don't have any instances of states
Sorry?
particularly. Your Excellency, I'm afraid I don't have any instances of states,
So
particular
does the Security
statements of
Council
states.
produce customary law?
Yes, Your Excellency.
Does it?
Security Council resolutions may form the basis of opinio juris. As
So
was
what do you
noted.
need in following up on Security Council resolutions to create customary law?
Is the reaction from the international community in that
Right.
respect.
So what
Your
reaction did you have
Excellency.
on ECOWAS?
Your
Mainly
Excel-
passivity, huh? Everybody kind of said, okay. So is that an opinio juris?
Or state practice.
Yeah.
Your Excellency, we would suggest that the absence of adverse reaction from the international community is evidence that this was acceptable practice in the case of ECOWAS.
Others might say a sigh is just a sigh, that when they just kept silent, they were maintaining a posture of ambivalence.
Of course, that is open to your
So
interpretation.
give us
Your
4 more
Excellency.
cases. Okay,
But
and go on.
furthermore to that, Your Excellency, we would also rely upon the UK, US, and France's intervention in Iraq. The UK.
I mean, if we were in the international court, the president would now say, would you please speak a little bit more slowly because the interpreters cannot really follow you. But even for,
But that was an important one.
The
So you
average-
suggested Iraq was the
yeah.
was
So
the
Iraq,
relevant
you mean
one.
1991 Iraq? Really?
Iraq in 1991, Your Excellency, which was
Was a
relied.
humanitarian intervention?
Yes, Your
Which
Excellency.
was generally recognized as permissible by the community of states?
Your Excellency, again, there was no adverse reaction from the international community regarding the UK, US, and
What was
France's.
the purpose of that let's say, thing or operation as stated in 678? I mean, you're referring to the 678,
You're
right?
talking about 1991.
Yes, Your Excellency.
The no-fly zones, not the initial.
Oh, you mean no-fly?
The no-fly zones
Your
over
brief is a
northern
bit
Iraq.
unclear on
Alright.
that point, but I take it it's the no-fly zone.
The no-fly zones over northern Iraq, the Kurdish area, Your
But
Excellencies.
wasn't that pursuant exactly to the argument at least raised by the United States and Great Britain was that that was pursuant to material breach, the very question I started you with and you refused to answer. So that is that kind of instance. What I am troubled by in your brief on this notion of humanitarian intervention is that you seem to cite me to Grenada, to Iraq, and it sounded like the other Iraq, the 2003. How do we distinguish a breach of the law from the creation of custom and opinio juris unless we can count the heads of states?
Yes, Your Excellency. I will respond to your question with 2 points. Firstly, regarding Iraq in 1991, although the states did also rely upon an implicit authorization of the Security Council in Resolution 688, nonetheless, they also relied upon humanitarian motives to justify their intervention.
But as I recall, there were states that said and continued to say throughout the 1990s that the no-fly zones were technically illegal.
Technically illegal.
So if it's technically illegal, you don't have opinio juris on your side.
And what this court deals with is technical legalities.
Your Excellency, we would submit that it is appropriate for this court to take into account the justifications forwarded by the United Kingdom government on the basis of humanitarian grounds for their intervention in Iraq.
Okay,
But,
next case.
Your Excellency, aside from those two cases, we would also rely on certain state practice which took place in the 1970s, including India's intervention in Bangladesh and also Tanzania's intervention in Uganda, which again were justified on humanitarian grounds, as the Indian representative before the United Nations Security Council made clear, and furthermore has been interpreted by very eminent jurists and academics and commentators to be instances of humanitarian intervention.
But one point my brother Sima has often raised is that you can't pick out the friends you like and count their voices and not fail to count the other voices.
Yes,
Can you point to anything that shows a consensus
Yes,
that
yes.
the intervention against Amin was, in fact, a legal intervention, or that Vietnam's invasion of Cambodia was legal, or that the Israeli action in Entebbe was legal?
As Your Excellency rightly points out, there are a number of commentators who both agree and disagree with whether this state practice is sufficient to form a rule of custom.
What's the authority of commentators? I mean, just professors. I mean, with all due regard. With all due regard. Can you kind of locate the scholarly commentators within, let's say, the law that we have to apply as the ICJ?
Your Excellency, with respect to these distinguished commentators, it is submitted that this court should take account of their opinions pursuant to Article 38(1)(d) of this court statute.
Although let me ask a question along that line, because sometimes the constitutive law may change. In the old days, commentators limited themselves to counting heads and reporting upon state practice. Now it's quite notorious that international law scholars often put forward what they would like to see become the law.
Especially American.
And one of the functions of judges is to be straight men to their president.
Yes, Your Excellencies, I appreciate your concern. However, finally, my final comment with regard to state practice is that should Your Excellency consider that the state practice that has been relied upon by the respondents is insufficient, then the practical implication of this would be that states would have to wait for genocide after genocide to occur before this rule can
we take that
crystallize.
point? But you also say in your brief that even 2-4 is not brought into play because you had no intention of staying forever. So I also wonder how long the Ravesian presence would have to endure for it to count as territorial conquest or political subjugation, to use your two phrases.
Your Excellency, as stated by the Ravesian president and as enclosed by the compromis, it stated that Rhodesia will not abandon the civilians of Alicante until a functioning government is able and willing to protect the civilians. This is part of the notion of the responsibility to protect doctrine, which we submit applies on the facts of this case. This is because a minimum threshold of humanitarian catastrophe was taking place in Alicante, and that in addition there was a manifest failure on behalf of the government of Alicante.
It's kind of a circular argument. If it's humanitarian, 2-4 doesn't count because it's only a temporary presence.
Your Excellency, it is our submission that the responsibility to protect doctrine operates within the framework of Article 2.4 of the United Nations Charter, which states that the use of force is prohibited where it is against the aims and purposes of the United Nations, and it is submitted that responsibility to protect is consistent with the aims and purposes of the United Nations.
Is that really what Article 2.4 says? The use of force is prohibited when it goes against the aims and purposes?
Your Excellency, specifically it says that...
What does it say before?
It states that the use of force is prohibited against the territorial integrity or political independence of another state, and also
or otherwise.
or otherwise in any manner inconsistent with the aims and purposes of the United Nations. And it is submitted that the responsibility to protect doctrine can be interpreted within the ambit of Article 2.4 of the United Nations Charter, and therefore does not constitute a
But what about the political independence part of that?
Your
phrase?
Excellency, we would submit that there's been no violation of the political independence of Alicanto for the reason that the objectives of the Revisian troops were not to overthrow the government of Alicanto or in any way to harm the government of Alicanto. In fact, the objectives were to assist the government of Alicanto in its protection of its civilians.
Now, again, on this, I'd like to focus on what the evidence is that this responsibility to protect is really within Article 38. Because in your brief, all you cite me to is a bunch of Canadians who think that's so, and a couple of reports from the high-level panel and so forth. If there is such a thing, can you show me real law?
Yes, Your Excellency. We submit that the distinguished academics from Canada should be taken into account. But in addition to this, additionally to this, Your Excellency, the responsibility to protect was outlined by the World Summit and incorporated into the World Summit Outcome Doctrine, which was unanimously endorsed by 170 states.
And with respect, I'd like you to point to in those documents, beyond the initial commission statement by those prominent Canadians, where the UN or any group of states or the General Assembly or the high-level summit has said that a state can take it upon themselves unilaterally to use force to defend R2P. Where does that happen?
Your Excellency, the outline of responsibility to protect as contained in the World Summit Outcome Document was adopted by the General Assembly in its first meeting of the 60th session. Furthermore, the doctrine has also been reaffirmed.
But where in that document does it say that you can do what I just described?
Your Excellency, according to paragraph 139 of both the World Summit Outcome Document and the subsequent General Assembly resolution, it states that states may act where there are acts of genocide, crimes against humanity, ethnic cleansing, or war crimes taking place.
To use force, does it say that?
No, Your Excellency, it does not explicitly say that force may be used.
And I notice you're not a party to the Genocide Convention, which is odd, of course, since you're a party to every other human rights treaty. But putting that aside, are you suggesting genocide occurred here?
Your Excellency, it is the respondent's contention that ethnic cleansing was taking place on the facts of this case.
Is that the same as genocide? There's a lot of recent law on that.
No, Your Excellency, it is not the same as genocide as recognised by both the Kristich case and also the Statich case before the International Tribunal for the former Rwanda.
How about giving case law from the ICJ, from this court, on ethnic cleansing v. genocide?
I'm afraid, Your Excellency, that the only case upon which has come before the ICJ dealing with this matter is the recent Bosnia genocide case in 2007, which quoted extensively from the case law of the ICTY and
Which
the
one?
ICJ.
Sorry?
The case before ICJ in 2007, the Bosnia genocide case, quoted extensively from both the case law of the ICTY and the ICTR.
Quoted?
Yes, Your Excellency.
Mm-hmm. So that's the reason why you don't name the case the ICJ case, because it just reproduced what the ICTY said?
Your Excellency, we would submit that the comments made by the Bosnia genocide case can be fully understood in the context of the cases that were brought before the Tribunal for Rwanda and the Tribunal for the former Yugoslavia.
So what did the ICJ say?
Your Excellency, the ICJ adopted a definition of ethnic cleansing, as stated by the final report of the UN Commission of Experts, as rendering an area ethnically homogeneous by using force or intimidation to remove from a given area persons of a specific ethnic or religious group. It is submitted that this is satisfied on the facts of this case, primarily
But
on...
I think my brother Seema's point is that under the recent case law of this court, that ethnic cleansing is distinct from genocide.
Yes, Your
Therefore,
Excellency.
whatever comfort you might wish to take from the the text of the Genocide Convention, that perhaps implicit in the Genocide Convention is a right to intervene if there is genocide, that doesn't give you any help here, correct?
Yes, Your Excellency. It is conceded that ethnic cleansing is to be distinct from genocide. However, as recognised by the General Assembly in its resolution, states may intervene where acts of genocide or ethnic cleansing are taking place, and it is the respondent's contention that ethnic cleansing was taking place.
What has the international court, what has this court said in connection with genocide and the obligation to prevent genocide. Does it make any hint that use of force may be permissible in cases of genocide, or what does it say?
Your Excellency, at paragraph 430 and 431 of this court's judgment in the Bosnia genocide case, this court stated that states have a legal obligation to prevent genocide from occurring. However, Your Excellency, we again would wish to bring...
But it said something else. It said something about the legal framework, the conditions under which that duty to prevent would have to be carried out, namely within the limits set by international law. And that was a hint that the court did not want to say, or even imply at least, that armed humanitarian intervention would be permissible.
Again, Your Excellency, of course, those paragraphs of the court's judgment are open to interpretation. However, we would submit that in extreme circumstances, intervention on humanitarian grounds that may involve the use of force, so long as the use of force does not go beyond what is absolutely necessary in the circumstances to prevent a humanitarian catastrophe from taking place, that this is permissible in international law.
Let me put it something of an exhaustion question to you, which is that before we go forward to expand the use of force to anything that an American might wish, say, hypothetically, why shouldn't we put it to states to use the old-fashioned remedy, the old 1950 Dean Acheson remedy? Go to the General Assembly, get yourself a Uniting for Peace resolution, which has been now invoked 4, 5, 6 times. There is an alternative to the Security Council. That's the General Assembly. Did you do that?
No, Your Excellency, the respondents did not seek recourse to the General Assembly in this case.
Fearful you would lose?
No, Your Excellency. The reason why recourse was not sought to the General Assembly was because the situation in Alicante was so pressing as to warrant intervention at the time that it took place. Furthermore, Your Excellency...
You can call a special session of the GA just as easily as an emergency session of the Security Council.
Of course, Your Excellency. But even if the General Assembly had been consulted on the matter, it is stated in the Charter of the United Nations that the General Assembly cannot decide a matter that is seized of by the Security Council. And furthermore...
But that has been reinterpreted since 1950. That's
again,
just my point.
Even still, Your Excellency, the General Assembly is not able to issue binding directions on action that may be taken by states in the face of pressing circumstances.
But the Uniting for Peace resolution is precisely what I think you would have wanted in order to get the authorization. And of course, as my learned colleague had suggested, Article 12, that business of no intervention with respect to the GA and the Security Council, this court itself has suggested, has been overturned or at least reinterpreted by subsequent practice. So why not the GA?
Your Excellency, of course we recognise that this was an option open to the respondent state. However, it is submitted that in light of the pressing circumstances, that Revizia needed to intervene at the time that it did in order to prevent another...
And what's the evidence before this court of how pressing this was?
Yes, Your Excellency. Now I shall turn to the intelligence point.
Okay, go ahead.
Your Excellency, aside from the classified Revisian intelligence data that shows imminent ethnic cleansing, we also rely upon Security Council Resolution 6620, which determined that the situation in Alicante was a threat to international peace and security. Furthermore, there is the report of the Secretary-General where he states at paragraph 10 that he is persuaded to a high level of certainty that a campaign of systematic violence is being planned against the Darfur civilians.
Let's put to one side the intelligence issue. Let's assume that indeed it's true. We accept as perhaps a stipulation between the two parties, that indeed there was a pressing humanitarian emergency. Is there something in the rules of the General Assembly that precludes your obtaining a position on the calendar, on the agenda, within 24 hours?
No, Your Excellency. There is nothing precluding Revizia from taking action through the General Assembly. However, it is... May I continue?
Finish.
However, it is submitted that given the pressing circumstances, that was the only reasonable option available to the Revisian state in order to effectively prevent ethnic cleansing from occurring.
Because you might have lost your vote there as well.
No, well, it is the respondent's contention that that is not the reason for not bringing the matter before the General Assembly, but because it would have been ineffective in any case to bring the matter before the General Assembly, and the intervention at the time it was taken was indeed necessary in the circumstances.
Okay, thank you very much.
Thank you. May it please the court.
So, and I give the floor to Mr. Rai. You have the floor, sir.
Mr. President, Your Excellencies, may it please the court. My name is Mahesh Rai, and I'm the co-agent for the Commonwealth of Rhodesia. In light with the two submissions that are made by the second agent for the applicant state, I will be making submissions on the following issues. First, whether the troops' conduct while in the service of the United Nations and operations to provide shelter triggers the responsibility of the Rhodesian state. And second, Your Excellencies, whether Rhodesia is under any international obligation to hand over Mr. Donati in order to be executed by the state of Alicanto. Your Excellency, the first issue concerns the fundamental principle in international law, as highlighted by my agents on the other side, that acts or omissions can only be found to trigger state responsibility where these acts can be attributed to a state, and secondly, where these acts breach an existing international obligation of that state. In response to the two submissions that are made by the learned agents from Alicanto, Your Excellencies, I'll be making the following two submissions. First, Your Excellencies, that the troops' conduct under UN MORPH cannot be attributed to the Rhodesian state as they were in the service of the United Nations. And in the alternative, Your Excellencies, the sexual engagement acts constituted private acts that do not trigger Rhodesia's responsibility. Second, Your Excellencies, that in any event, the troops' conduct did not breach any of Rhodesia's international obligations. Before I move on to the attribution point, I wish to highlight to this court that the conduct that is being complained of over here falls into two different time frames. The first, preceding 31st July 2008, concerning UN MORPH's radio broadcast and the allegations of sexual exploitation. And second, that after 1st of August 2008, under Operation Provide Shelter, which, Your Excellencies, only concerns the continued radio broadcasting, as has been stated in paragraphs 50 and 51 of the complaint.
And counsel, is it your position that the SOFA terminated after the termination of the mandate?
Your Excellencies, it is our submission that the SOFA did terminate after the mandate, since the SOFA is only made in relation to United Nations peacekeeping operations. Furthermore, Your Excellencies, by virtue of Article 33 of the Vienna Convention on the Law of Treaties, since Rhodesia is not a party to the SOFA, as it has been concluded between Alicanto and the United Nations, the obligations within the SOFA after the termination of UN MORPH's mandate cannot bind the state of Rhodesia.
But it can bind you before.
Yes, Your Excellencies, we do.
And therefore, what do you say about Article 47B of the SOFA, which basically says that the military members of the UN peacekeeping shall be subject to the exclusive jurisdiction of their respective participating states. So you are responsible for anything that occurred, at least while the SOFA was in effect. Would you acknowledge that much?
Yes, Your Excellencies, we acknowledge that we retained exclusive criminal jurisdiction over the region peacekeepers.
So why haven't you prosecuted the sexual issues or the broadcasting issues if they were in fact a violation of the local law?
Your Excellencies, I'll answer your questions in two parts in relation to the two conduct being complained of. With regards to the radio broadcast, it is our submission that it falls within the mandate of Resolution 5440. With regards to the Sexual Exploitation Acts, Your Excellencies, and this directly responds to the due diligence obligations that the applicants have submitted, is the correct test to be employed in this situation. As has been stated by Prince Zeid, the Special Legal Advisor to the Secretary General in his Zeid report, at paragraph 80, Your Excellencies, paragraph 47B of the Status of Forces Agreement entails a right of the sovereign state to prosecute and not an obligation. Nonetheless, Your Excellencies, I understand your concern that the victims of sexual exploitation will be left without any redress.
Let me ask you, though, about a quite extraordinary claim that you make at page 26 and 27 of your submission, which is that sexual relations with underage girls do not constitute any violation of international law. Now, the Human Rights Committee has condemned countries that permit marriage, real marriage, at the age of 9 or 13, as seems to be presently a practice in Chad, for example. If marriage is forbidden under the ICCPR at the age of 13, how could sexual relations not pro tanto be a violation of the same provision?
Your Excellencies, the respondent state does not wish to contend right now in its oral pleadings that the conduct did not trigger any international humanitarian law obligation or human rights violation.
At what age? Are we talking about 13, 14, 15? Does it matter what the local law says?
Your Excellencies, it matters what the local law says, since although the Convention on the Rights of the Child states that a child is defined as a person under the age of 18, it also leaves the discretion of the age of consent, Your Excellencies, to the relevant states. And we would submit, by virtue of the clarifications to the compromise, that the state of consent, I beg your pardon, the age of consent in Alicante is at the age of 15. Nonetheless, Your Excellencies, we do not deny that these sexual exploitation allegations constitute grave violations. What we do assert, Your Excellencies, is, and this is the crucial point in this issue, that the Commission of Inquiry started by the Secretary General concluded in October 2007 that these acts were committed off-duty and outside of Chmpnshp, Your Excellencies.
All the more why the UN should not be able to prosecute these. These are your troops. So therefore, under any understanding of responsibility, it's your responsibility to take care of what they do outside their duties to the UN, isn't it?
Yes, Your Excellencies, we agree with your position. However, it is our submission. The fact that we have not prosecuted 11 months after the Commission of Inquiry concluded its investigations up till the conclusion of this compromise, Your Excellencies, does not mean that the revision state does not intend to prosecute.
So what would be the time limit
Your
for
Excellencies,
the reasonable chance to undertake your own prosecution?
Your Excellencies, the respondent state was hard-pressed to find many instances in which the troop contributing country chose to prosecute. However, Your Excellencies, bringing to light the reported case of Dieder Boguet, a United Nations French logistic officer, who was actually found to be in violation of the prohibition against rape of girls in many African missions, over 20 girls, Your Excellencies. In September 2004, the Commission of Inquiry concluded its report. The French state only chose to bring prosecutions on the 8th of September 2008. This was a delay of 4 years, Your Excellencies. Hence, in our situation...
So you're planning to wait for another 3 years? Or?
Most certainly not, Your Excellencies. We do not intend to wait for that period of
I mean,
time.
I will certainly take the point that I assume you're implicitly making, which is that over the years, the UN was extremely remiss in failing to address this as an issue. And often, even in the great Derek Bowett's book, he says from 50, 60 years ago, there have been rumors of this, but unsubstantiated. It's only recently the UN has taken this on board. But surely you, as the sending state in a modern setting, have the duty of very prompt prosecution, if only to repress further violations.
Yes, Your Excellencies. And we submit that in light of what the esteemed learned publicist, Mr. David Bowett, has actually highlighted in his book, United Nations Forces, that these acts have consistently occurred. However, we would submit, Your Excellencies, that when Rhodesia took effective control of Operation Provide Shelter on 1st of August 2008, it ensured that there was no recurrence of such acts. Hence, Your Excellencies, this also goes towards our due diligence obligations.
But you would have no problem then with an order from this court directing you to investigate and, if necessary, prosecute in due reasonable time any acts before that?
Your Excellencies, it is up to Your Excellencies' discretion to hold that we are under an obligation to prosecute. However, as this court has held in its Avena judgment, this court cannot direct the judicial organs of the Rhodesian state.
At least we can't direct the U.S., I guess.
Most certainly, but this agent will undertake to comply with Your Excellency's decision.
But if you both were members of the ICC, if you failed to undertake reasonably prompt prosecution, you would not have fulfilled the shelter of complementarity, correct?
Your Excellencies, if we had failed to prosecute within a reasonable time, then we submit yes. However, here, Your Excellencies, a mere 11 months has passed. We do not have any information when were the troops repatriated to their home country and when the investigations were conducted. Your Excellencies will appreciate that the two countries contending this case are on different continents. The gathering of evidence and witness statements, Your Excellencies, is crucial.
That struck me, Counselor, actually, that this is an old-fashioned case of salt water colonialism, not just two neighboring states. This is post-colonial intervention.
Your Excellencies, we would submit that...
Which might be a reason why, not in doctrine perhaps, but in sensibility, one should be even more acute about failures to protect the local inhabitants from the depredations of a former colonial.
Yes, Your Excellencies, we do note your point. However, as highlighted by the Inter-American Court of Human Rights in the Velasquez-Rodriguez case, Your Excellencies, the mere act of the violation of the conduct in a private capacity does not entail a state's responsibility.
But Velasquez-Rodriguez also says that failure to repress becomes a public act.
Yes, Your Excellencies. In that case, the Honduran authorities did not take any steps at all in order to prevent the acts from occurring again. In our case, Your Excellencies...
Or to investigate those that had been committed under the Ensure, right?
Yes, Your Excellencies. However, we would submit, Your Excellencies, that by virtue of the fact that the Sexual Exploitation Acts stopped the minute we came to have effective control of the operation, can be taken to be an indication that we did investigate and prevent a recurrence. And Your Excellencies will note from the many examples in Congo, in Burundi, in Sierra Leone, Your Excellencies, that even after the first reports of sexual exploitation arose, there was repeated recurrence of these acts.
I just want to be clear in terms of your government's position here. Is it your position that all your human rights obligations, whether under the ICCPR, the CEDAW, or the Rights of the Child Convention, all of these apply in the territory of Alicanto, or are there differences among those treaties?
Your Excellencies, we would submit that with regards to, as this court has held in the Palestinian Wall Advisory Opinion, where a state exercises its jurisdiction over individuals outside of its territory, the ICCPR and the Convention on the Rights of the Child apply, as held in paragraphs 111 and 113 of this court's judgment. Further to that, Your Excellencies, General Command number...
Judgment?
Sorry, Your Excellencies?
This court's judgment?
I beg your pardon, Your Excellencies, advisory opinion. Your Excellencies, by virtue of that, we would submit that we did comply with our human rights
But not
obligations.
CEDAW.
Sorry?
CEDAW does not apply?
Your Excellencies, CEDAW does not have a jurisdictional clause, and hence we would also contend, Your Excellencies, that it does apply extraterritorially.
Is there recent case law by this court according to which the fact that you don't have, let's say, a jurisdictional clause in a human rights treaty cannot be seen as excluding such a clause in treaties which don't, well, okay, I start again, it's a bit complicated. Is there a recent judgment of the court, a decision of the court, relating to a human rights treaty which does not have anything on comparable to the references to jurisdictional scope, where the court says we just read it as in the same way as we did in the Wrld opinion, as extending beyond borders? Is there something relatively very recent?
Your Excellencies, this agent is not aware of any recent case which deals with this matter. However, Your Excellencies, we would hold that since...
I'm referring to the order of the court in the case of Georgia versus Russia of October, I think, 15. And I'm sure you have read that case where the matter was whether CERD can be read as having, let's say, as applying beyond borders.
Well, Your Excellencies, in this situation, from what I recall, it was held that it could apply beyond borders, Your Excellencies. And even if this agent is wrong in his reading of this court's judgment, we would submit that by virtue of paragraph 53 of this compromise, which states that the CEDAW is a treaty to which both Alicanto and Rhodesia are parties to, they apply in their interrelations, Your Excellencies. And this brings me to my point on the radio broadcast and its legality. We would submit, Your Excellencies, that contrary to what the applicants have submitted, the radio broadcast did not fall outside the mandate of Resolution 5440. This is because the mandate provides, in operative paragraph 4, for UNMORPH to employ all necessary means.
But that doesn't help you during your period of unilateral presence, correct?
Yes, Your Excellencies. And if Your Excellencies are satisfied that Resolution 5440 validates the radio broadcast under UNMORPH, I shall proceed under OPS, Your Excellencies. We would submit that in a post-conflict situation, as has been referred to by our learned friends, Secretary General Boutros Boutros-Ghali has actually commented in paragraph 55 in his An Agenda for Peace that peace building is just as important as peacekeeping, Your Excellencies.
Well, this is very interesting because some would read the facts in this case to suggest that your radio broadcast actually may have precipitated some of the ethnic conflict in the territory. What do you say to that? That is, maybe these are not quite as innocent as they appear, and maybe they look a little bit like the ones in Rwanda at a particular sad moment in time.
Your Excellencies, we would contend that for the content to amount to an intervention, to amount to hate speech or limitation under Article 19 of the ICCPR, Your Excellencies, General Command number 19 of the Human Rights Committee holds that it must incite racial violence or hatred. In our situation, Your Excellencies, I believe Your Excellencies are referring to paragraphs 26 onwards. In these situations, every attempt by the Alicantan state to discriminate against the Dasu population has been met with violence. Your Excellencies, in March 2008, when they passed an ordinance requiring married women to register their properties in their husbands' names, riots broke out in the Malata province, which the Alicantan state said was attributed to New Year's Eve celebrations. Second, Your Excellencies, on 15th of August, when they implemented Talonic law, this revoked hundreds of Dasu women's property titles and granted them to the Zawabi population. This, Your Excellencies, resulted in paragraph 45, where skirmishes
These
broke
are
out.
quite credible violations of treaty obligations.
Yes, Your Excellencies.
Why is it that you, as sort of the Mother Teresa, is going around enforcing those treaty obligations? Those treaty obligations have discrete places to go to, and you're welcome to try to instigate those procedures. I fail to see what those have to do unless you're talking about some notion of material breach that you are now responding to. Is this that kind of argument? That because they breached this human rights treaty, you can too?
Your Excellencies, we submit that we are not mounting a countermeasure to Alicanto's breach of the human rights treaties. We would submit that the radio broadcast was part of our humanitarian assistance that we were providing for. These radio programs, Your Excellencies, are not an anomaly. As you would see in 1992 and 1993, Radio Untact, although it was started up for providing information for the right to vote, Your Excellencies, also highlighted the discrimination against the Vietnamese population. In Congo, Your Excellencies, Radio Okapi was used to establish common grounds between the two ethnically diverse villages, Your Excellencies, in order to allow for a post-conflict peace situation. Here, Your Excellencies, we would submit that the radio broadcast did immediately that, since, Your Excellencies, the point that divides both the Dasu and the Zwabi is their interpretation of the Talmudic faith. And every single attempt, 3 attempts, Your Excellencies, in the compromise by the Alicantan government to restrict the women's rights have been met with violence and skirmishes.
But let me put a question that's really quite in play in the United Nations community at the moment, which is that Article 20 prohibits any advocacy of religious hatred. So in privileging your interpretation of the appropriate religious law to be applied in Alicante, isn't it implicit that you are deriding the view of the role of women, the God-given role of women that's taken by the actual sovereign of that country?
Your
It's
Excellencies,
a form of religious hatred or religious derision, is it not?
Your Excellencies, we would submit that this information intervention that was carried out by both UN Morph Radio and Operation Provide Shelter does not amount to an incitement of religious violence, since Your Excellencies would note that in accordance with Article 19.3 of the ICCPR, the grounds on which the right to free information can be restricted are public morals, public safety, and the applicants left out one more, public health, Your Excellencies. The radio program concerned educational and cultural programs for access to education, reproductive rights, and also, Your Excellencies, it is hard to see how anything can be more relevant to public health than reproductive rights. It is our submission, Your Excellencies, that we upheld the International Covenant on Civil and Political Rights in ensuring these rights of Alicantans. Your Excellencies, if I may now turn...
Are you arguing that the reservation taken on grounds of Sharia was something you could overturn or disregard?
Your Excellencies, as provided in Article 28 of the CEDAW Convention, a reservation that goes against the object and the purpose of the treaty can be regarded as invalid. And Your Excellencies, as has been held with, in regards to the rule for reservations for human rights treaties by the European Court of Human Rights in Lozidou versus Turkey, Your Excellencies, where such reservations go against the very object and purpose.
But if you take ijtihad seriously, then simply having a reservation on grounds of Sharia does not necessarily go beyond the reach of measure. Ijtihad can give you a more modern interpretation of what the Prophet meant. So you should not suppose that because there's a Sharia reservation, you have a free hand to give your own modernization
Your
of
Excellencies,
that law.
Yes, Your Excellencies. Several other countries have lodged such general reservations which do not specify the grounds on which they object.
Can you derive some authority from very recent or current work of the ILC, of the International Law Commission,
from the
on the point of across-the-border reservations?
I beg your pardon, across the border
Sorry.
reservation?
Can you point us to recent or even current work of the International Law Commission which deals precisely with, let's say, certain types of non-permissible reservations?
Your Excellencies, we would submit that we would not need to turn to the work of the International Law Commission.
Yeah, but
I am not aware of reservations.
the Commission has been dealing now for, I don't know, many, many years with reports of Professor Alain Pili on reservations to multilateral treaties and has brought out guidelines really spelling out how to read 19C and the consequences. Like that's pretty relevant. I mean, in view of the general, let's say, in the light of the general view of ILC, more or less pronouncing customary law, etc.
Yes, Your Excellency. The ILC study on the effect of reservations to multilateral treaties concerns the general nature, the general treaties, the general nature of the obligations to all the treaties that have been concluded. However, we would submit that the rule in relation to a human rights treaty must be accorded special significance. This is because, Your Excellencies, in the esteemed opinion of learned publicists such as Malcolm Shaw and Ian Brownlee, where such reservations are made to the fundamental provisions in such human rights treaties, they defeat the very object and purpose of such treaties, Your
Yes, but
Excellencies.
As
That's precisely what the ILC says, right? So it would really buttress the point you want to make.
Yes, Your Excellencies. And the ILC also says that in relation to this court's judgment in the reservation to the General Hague Convention case, that in certain
Is that the
circumstances... Sorry, Your Excellencies?
Judgment?
Advisory opinion, I beg your pardon once again, Your Excellencies, that the other party, Rhodesia, is entitled to consider the breaching party not a signatory to the treaty. And here, Your Excellencies, we would submit that even in this alternative submission, we can also rely on the ICCPR obligations of the Rhodesian state.
Did you object to that reservation as being in violation of the object and purpose when you could?
Your Excellencies, the compromise is entirely silent on this.
And if you did not, what gives you the right now to say anything about it under Articles 19 through 22 of the Vienna Convention rules on reservations? Isn't the point that when you object as a state, at that time, you may be free to take a position as to whether that treaty is or is not valid as between those two states? Isn't that an important point? And if you didn't make that, now it's too late to say anything about it.
Yes, Your Excellencies. If I can have additional time to answer your question and also to address briefly the point of Mr. Donati, Your Excellencies. We would submit that we do not have any information on the reservation, the objection to the reservation by Alicantan State. However, Your Excellencies is right to point out that we might have lost our right in order to consider this treaty as binding. Nonetheless, Your Excellencies, we can still rely on Articles 18 and Articles 19 of the ICCPR, which provides, Your Excellencies, that the views of the minority population should not be disregarded in relation to the restrictions on the freedom of information, as has been held by the Human Rights
If
Committee.
the President would permit me, just one question on the interrelationship between the two halves of your argument. You've been trying to justify this as a humanitarian intervention. And I take it it's your claim that any radio broadcast that you need to bring women up to the modern standard of rights and entitlements is part and parcel of that humanitarian intervention. I can think of a lot of countries where that kind of claim could be made. The emergency quality of the R2P claim made is really diluted by the fact that you're saying any restriction that violates CEDAW is actionable under your radio broadcasts incident to your armed intervention.
Your Excellencies, we would submit that the radio broadcast, instead of fueling the divisions within the community, was aimed at the healing of the Alicante community, since, as I've highlighted, Your Excellencies, that the deprivation of women's rights was primarily one of the reasons that actually incited the violence between the Dasu and the Zavabi groups. And, Your Excellencies, in our situation, we broadcasted information on women's rights from the most objective source possible, the United Nations News Radio Service.
You could have taken it up in Universal Periodic Review in the Human Rights Council with much less flamboyance.
Yes, Your Excellencies. However, as has been stated in the compromise, we are not parties to the optional protocol to the ICCPR, and hence we would
No,
not
but
have
you are in the Human Rights Council by dint of being a state.
We're not talking about the committee now, but the Human Rights Council.
I beg your pardon, Your Excellencies. In our situation, we would submit, Your Excellencies, that we also had a positive duty while we were in the state of Alicante to contribute to the peace-building process. And this, Your Excellencies, as has been seen in Burundi between the Hutus and Tutsis, has been carried out by the radio program Search for Common Ground. In our situation, Your Excellencies, by encouraging dialogue between the both sections of the Alicantan community, we sought as a further measure towards the responsibility to protect. With regards to Picado Donati, if I can have leave to just have about 1 minute to sum up my pleadings, Your Excellencies.
I think we are already over time.
Yes, Your Excellencies.
Okay. Okay, sum up.
Your Excellencies, the fundamental breach is that of Article 6.2 of the ICCPR, which provides that the death penalty cannot be imposed retrospectively. By virtue of Article 4.2 of the ICCPR, this is a non-derogable right, as has been held by the Human Rights Committee in Kelly versus Jamaica, where such fundamental violations have occurred, the death penalty becomes invalid, and as a result of this, Your Excellencies, the Rhodesian state is
Let's
under
be
no...
clear. If Alicante says we won't apply the death penalty. Just give us Donati. That's okay?
Your Excellencies, if Alicanto provides assurances that they will not execute him, we will be willing to hand him over. However, this is not the pleading of the Alicantan state. They plead, Your Excellencies, that we hand him over so that his lawful sentence can be carried out. Take note, Your Excellencies, that in Alicanto they have also enacted a law that provides that a death sentence can be carried out 12 years after it has been passed, and also all the appeals process has been exhausted by the public defender. In Kelly versus Jamaica, Your Excellencies, this was held to be the crucial criteria in order to determine whether the death penalty would be invalid. And hence, Your Excellencies, we would submit that we are under no international obligation to hand him over.
Okay, thank you very much.
Thank you for your time, Your Excellencies.
So I call on. Okay, now I call on counsel for the applicant to give his rebuttal. It's 2 minutes, right? 2 minutes?
2 minutes, Mr. President. Your Excellencies, Alicanto will now exercise its right of rebuttal. And at the end of the day, when delivering the judgment, not all the legal scholars of the world, not all professors of international law or academics will divert the court from this inevitable conclusion. There is no opinio juris as to sustain a rule of humanitarian intervention. This has not been only widely rejected in 1999, but in every single case cited by the respondents as a state practice for humanitarian intervention. This rule of international law, quite simply, has not come into existence.
Is there lex ferenda? Is it emerging? Is it soft law becoming harder?
Indeed, Your Excellency, and soft law is nowhere to be found in Article 38 as rules applicable to legal disputes before the court. Your Excellencies, as to the second point...
Although it's your duty to show that the intervention was illegal, not theirs to show it was legal, right?
We respectfully disagree, Your Excellency. The burden of proof would lie within the respondents in the specific case to provide for the legality of their own actions. And they cannot, quite simply because the community has been very clear in this respect, and the court will not be able to find one instance with wide acceptance.
One more question on this line. At least suppose that it fulfills the standard put by Chmpnshp, that it's legitimate if illegal.
Your Excellency, Judge Antonio Cassese in his article, although argued for the moral appeal of this rule, did contend that it was nonetheless illegal under international law.
And you're a pure positivist. You think moral content has nothing to do with the evolution of opinio juris?
We believe, Your Excellency, in the words of Judge Alvarez, that this court is to apply the legal technicalities, not the moral technicalities.
Positivism, triumphant.
That may win you one vote on the court. But I would ask your best answer to my more teleological approach to life.
And we respectfully, seeing that my time is up, Mr. President.
Yeah, very brief, very succinct.
Indeed. The applicant puts forward, Your Excellency, that in the absence of the recurrent judgments of this court as to find customary law, and in the absence of the very requirements of Article 38, 1b of the statute, then the court cannot effectively apply a rule which does not exist in international law, as morally appealing as it might be. Your Excellencies, if there are no further questions, the applicants rest their case.
The time is up. Yeah. Thank you
Mr.
very
President.
much. Okay. Ms. Lee,
Your
counter
Excellencies. Mr. President, Your Excellencies, I shall be exercising the right of sur rebuttal on behalf of the respondent. Your Excellencies, in relation to the applicant's allegation that there is insufficient opinio juris, it is submitted that the international community has moved on since 1999. Most specifically, the endorsement of the responsibility to protect doctrine by 170 states unanimously at the World Summit indicates that the international community has moved on, and this is the position to be applied.
How can you say that when, after the Kosovo intervention, I think in 1999, there was 130-odd countries speaking out against the right to intervention, and then if, let's say, several years later, 170-odd countries speak out in favor of responsibility to protect, that you can really read armed force into that later, let's say, expression of a consensus? Because my interpretation would be, if you had about 80% of states in 1999 coming out very clearly against, then I think you would have a problem in saying that in 2000, I don't know, 5 or so, they had quietly accepted it in the meantime.
Your Excellency, I understand your concern. However, as made out in the respondents' main submissions, the backlash against the NATO intervention in Kosovo can be distinguished on the facts of that case, and that affords an explanation for the rejection of humanitarian intervention in 1999.
But taking the most recent activity, there has been a series of consultations done by the special advisor to the Secretary General, Mr. Edward Luck, in and around the General Assembly on what they understand R2P to mean. And like it or not, responsibility to protect, like it or not, the view of most of the members of the General Assembly is it does not entail the use of force on a unilateral basis. See the recent Stanley Foundation précis of Mr. Luck's consultations. What would you make of that? Those are state acts, if you will, expressions of opinion. Alas, alack, but they're true.
Your Excellency, we agree that is entirely true. However, if I may refer Your Excellencies to the compromise, there are no facts.
Go ahead.
There are no facts in the compromise which show that Revisian troops used force whilst they were present in Alicantan territory. In paragraph 46 of the compromise, the Revisian troops were present in Alicante only to maintain the peace and only carried out such operations as to amount to policing functions, and therefore there was no indication that any force was used during Revisia's operation.
And therefore, even if we find that R2P doesn't apply, we should still fine for you because they were there as kind of Quaker witnesses?
No, Your Excellency. Again, this would be our alternative submission under Article 53, but our primary submission is that Revisian troops were justified on humanitarian grounds to respond to the situation taking place in Alicante.
And Counsel, we never let you get to Article 53, but I am curious about one small point, and that is RFAN. Is it your view that RFAN is a regional organization, or is it your view that RFAN is a collective security organization, and does that make any difference?
Yes, Your Excellency, we would submit that RFAN is a regional agency for the purposes of Article 53 of the United Nations Charter. And since Revisia acted with the endorsement of the RFAN regional arrangement, that permits Revisia to intervene in Alicante and is therefore
this
justified.
Is my problem, and I don't understand why you did not make the argument that it is actually a collective security organization like NATO, in which case Article 53 would not necessarily stand in your way. You'd be prime Article 51 material. Why are you not making that argument?
Your Excellency, I do appreciate the point made. However, was time permitting, the respondents would have sought to rely upon such an argument as highlighted by Your Excellency.
So you would be in an Article 51 situation in our case?
Your Excellency, that would have been our argument in the further alternative. However,
could you really do that in a say state-of-the-art way, saying that you were acting on the basis of Article 51? I mean, you're not. Well, okay. I leave polemics aside. You're
Your
not the United
Excellency.
States, I wanted to say. But,
They may be.
well, they may be, but not you are not the U.S. according to
But what you're really making is an old-fashioned Tom Ferrer claim that there could be a treaty in which countries would agree to forcible intervention in any one of their members to restore democracy, to restore the state of the legitimate government, right? This is it's a treaty-based waiver of sovereignty. Is that correct?
Yes, Your Excellency.
But then you'd want to have very explicit language in the
Yes.
regional framework to make that plain.
Of course, Your Excellency.
Do you have that language?
No, Your Excellency, we don't have that language on the facts of the compromise before us. However, time permitting, I'm afraid I'm unable to elaborate on this argument before this court. And I just wish to sum up upon the respondent's primary argument that intervention was justified on humanitarian grounds. If I may leave you with the words of the former Secretary General Kofi Annan, if humanitarian intervention is indeed an unacceptable assault on sovereignty, how should we respond to a Rwanda, to a Srebrenica, to gross and systematic violations of human rights that affront every precept of our common humanity?
Okay. So I think time has run out.
Your Excellency, we rest our case.
We'll take your technical, legal argument at heart, and the court will now engage in its deliberation. I think you can be safe that the break will take 15 minutes at least, but then be prepared to be back and we'll render our decision. Thank you.
Thank you.
Please be seated. The winner is the applicant. We're not going to give any reasons why.